Okay, thank you. This is the last meeting of the History Club, and we have a fantastic speaker.
I thought I was speaking.
Dan Cohen, who really needs no introduction in Palmer, because everybody knows who Dan Cohen is. But I'll tell you, he was a New York lawyer. He practiced in all the courts in New York, and he was a very excellent lawyer. And without further ado, Dan Cohen.
I'll put this thing on here to get myself going if I can do it. Yeah, can you hear me?
Yeah.
Okay, that's the important thing. Well, good morning, folks. Thank you for coming. I'm glad to be here, but before I begin, I hope what I say has some meaning. Not like what happened years ago when that balloon was flying over the Alps in Europe, and there were two men in the balloon, and they were lost. And they see a guy climbing up the Alps wearing snowshoes. And one guy in the balloon shouts down to him, "Excuse me, sir, could you tell us, where are we?" The guy down below in snowshoes looks up and says, "You're in a balloon." First guy in the balloon turns to the second guy and says, "That man down there is a lawyer." Why is he a lawyer? Because everything he told us is 100% accurate and totally useless. So with that introduction, I will do a discussion of what is my true first love, well, really the second love, you know that, and it's the law. No more jokes, it's a very serious topic. The law. Thank God we have the law. Without it, where would we be? It is wonderful. And what is the law? Well, the law has been defined as a set of rules and regulations that govern the transaction between the state and the people and among the people themselves, and it has various aspects in civil, criminal, and domestic areas. Nice big broad definition. But how did it begin? Where did law begin? Well, of course, it goes way back to the caveman, you know, the best man with the club took the girl and had to defend the rights for people taking the girl back. It began way back in ancient civilization, where the strength of a man made him the leader. The caveman became the leader. He set down the law. He decided how his community is going to work. That's simple enough. When we got to be more evolutionary and more human beings, we became a group of society. And the group picked their leader to be. And he generally was a king or a dictator or an emperor, someone who had the authority and the ability to take command and rule. And he ruled very well. And he ruled sufficiently that ultimately he was able to put his laws in different codes. And one of the codes of laws going way back to the beginning of time was the famous codes of Hammurabi. He existed about 1800 BC, a wonderful gentleman at his day. And his code he put in stone, in an obelisk that he put in the center of the town for all those who could read to see what it was. And that began the beginning of the codes of law. We had Hammurabi. Following him, when the Roman emperors came into authority under the great Caesars, they put their law into Roman codes. And that became the law of Rome. But it became so diversified that it had to be put together in a particular form. So along came this guy Justinian, Byzantine emperor. He put the law into a code, the Code of Justinian. Then we ultimately came along and we got the Code of Napoleon. And then finally we got to England with common law. And then we came to the United States, our famous U.S. Constitution. With that, I'll leave you. You now know the history of the law. No. The fact is, the law evolved strenuously from all of those points. But to me, the three most important concepts ever written in the law are just well known to all, and they exist. They were known as the Magna Carta. Well, before that, the Ten Commandments, the Magna Carta, and the U.S. Constitution. Nothing could be greater than those three documents. Certainly, we all know the Ten Commandments, but unfortunately, a lot of folks consider that too religious. I am the Lord thy God. They can't use the name in vain, that sort of stuff. So we have legal problems in our country with that. But it is a fundamental beginnings of law that we really know about in writing, that we understood the Ten Commandments. Marvelous. But the second greatest document, and it really is the greatest one, is the Magna Carta. The Magna Carta, as you know, was an agreement where King John in 1215 decided I had enough being king. I can't make laws without consent of the people. I can't just hire people. I can't try and convict people. I got to give them the right to have due process, the right to have a form of trial by jury. And the Lord said, you better do it or we're overthrowing you. So he signed the famous, very clearly, he signed the Magna Carta. But the Magna Carta, as good as it was, few people know it was anti-Semitic. Now that's quite a thing to say. Everyone in high school knows the Magna Carta. In college, you all heard about it. That's the beginnings of our Constitution. All well and good. But it has an anti-Semitic statement and provision in it. First, the main clause of the Magna Carta. The clause that everybody loves, recites, and this is the one that gave us our U.S. Constitution. It reads, quote, Clause 39, no free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any way, nor will we proceed with force against him or send others to do so except by the, here's the key language, lawful judgment of his equals or by the law of the land. That became, never heard of that in the history of the world until that day. A king can do no wrong. What's this law of the land crap? Where did that come from? Well, it came from the Magna Carta. They decided that, Mr. King, yes, you can be king, but you're not going to declare war without the consent of the nobles. You're not going to hire and take away our peons and put them in your army without our consent. You can't just try them and behead them without a trial, without people of their peers sitting in and deciding right from wrong, guilt or innocent. This became the Magna Carta. This became a judgment of his equals or the law of the land. All well and good. But people seem to forget, in those days, the Jew was not very well liked. He was very much looked down upon. Under the canons of the church at that time, handling money was illegal for the Christians. So who could handle money? The Jews. And the Jews did. They had plenty of it. And they lent it. And they lent it at huge interest rates, usury rates. They had no laws on that other than what the king would decide was good law. And the king made his decision on what is usury and what is not. And the kings borrowed money from the Jews. But worse, the king suppressed the Jews terribly. They took away their property, took away their money, took away their capital, many times wouldn't pay back loans, many times exonerated debtors from paying debts to the Jews, did terrible things. And when they told the Jew, you got to pay huge interest rates and assessments, Jews were upset. But what could they do? It was the king, and the king hated them. They hated the king, but they had to comply. There are terrible examples on record where the king brought the Jews before him, told them, you're going to pay me a taxation for running your business, or else I'll take away all your property, or else you're going to be put in jail. And when the Jew refused to do it, literally, his teeth were taken out by force until he would comply. Torture was used extensively. That was the days of our famous Magna Carta. So, finally, in Clause 10, they put in the Clause 10 in the Magna Carta this phrase. If anyone has taken a loan from Jews, great or small, and dies before the debt is paid, the debt is not to incur interest. As long as the heir is under age, whoever he may hold him, and the debt comes into our hands, we will take only the principal. In other words, stop the interest when it comes to a loan from a Jew when there are children involved. Where did that come into the Magna Carta? Why would that come in? Because in those days, the transaction and finances were heavily guarded, controlled, and engaged in the business by Jews. So the Magna Carta was really somewhat of an anti-Semitic doctrine, but nonetheless, it's the forerunner of the greatest document ever written, the United States Supreme Court, the United States Constitution. That is the doctrine which I'm amazed with it. I think we all should be amazed with it. It lasts hundreds of years, and with God's willing, may it last many thousands more. Our Constitution, we all know what it is and how it came about. But the question real is, has it worked? Has our law changed? Has the Constitution been effective? Yes, the answer is it has worked. It is effective. Our Constitution is to be cherished forever. How has it really changed? Well, let's look at a few of the changes. In the criminal law, one of the most important changes would be torture. Torture was very common in ancient days. We know that. It became very common in ancient England. When England came over into our country and we had our colonists, torture was the way of the world. We had a star chamber. A man was arrested and be found guilty, that's fine, but let's face it, in order for a man to be found guilty, you need evidence. What could be the best evidence than the man himself? So he was tortured, put on the rack, put in boiling oil, fingernails pulled out, anything to get him to admit he did wrong and to give the facts. Well, thank God our early geniuses in our Constitution said we can't have that. This law of torture has come to an end. We must stop it. So when we had the Constitution, they prepared in there the Eighth Amendment, which clearly says that cruel and unusual punishment can no longer be inflicted. If you want to get it convicted, other than the man's mouth, you cannot call a defendant to the stand and ask him, did you do it? It seems so silly. Wouldn't that be a natural thing to want to do? Yes. But in view of the torture, we can't have a man come in and testify where his very words could be the indictment of him, and if they're brought out by torture, it's against all that's decent and moral. So our forefathers, James Madison, very effectively put in the Constitution, that famous Eighth Amendment. And by the way, it's been not only followed in our Constitution, it became quite effective in the Geneva Convention. The Geneva Convention says they prohibited all type of degrading and humiliating conduct or outrageous to human dignity. Wow, that's pretty far-fetched. Putting a man on in women's clothing when he's a Muslim, and that would be a terrible thing, is degrading and humiliating. Making fun of him is degrading and humiliating. Do we consider that torture? Well, we don't, but the Geneva Convention might. But the idea is we are facing the concept that it is wrong to use such practices to get a conviction. Of course, unfortunately, when the Iraq came about, we had President Bush, and Cheney think otherwise. They felt there's nothing wrong with alternative interrogated techniques, euphemistic for torture. They felt it was perfectly all right to do that, to get confessions from these terrorists. We can't have them blowing us up without knowing who started them, how it came about, how they got their dynamite, who's involved with them. So we will give them torture, a form of terrible things to be done. You all know about Abu Ghraib, the prison that was in Iraq, and where they tortured these terrorists terribly. They thought they were going to kill them, line them up to be shot, and it was a fake execution. They used wires on them to electrocute them, standing positions, deprive them of food, terrible things. And of course, the lower soldiers were found guilty of violating our Eighth Amendment. They were punished, but it stopped at the lower echelon of the military. It didn't go up to the generals. It went to a Major Kopinski, I think her name was. She was in charge of the area, but it stopped. It didn't go to the generals, and it certainly didn't go up to the person in charge, Cheney or Bush, who authorized it. Should they be responsible for violating the Eighth Amendment? Of course they should, but it's not politics, so we ended over there. Anyway, that's one tremendous achievement of our Constitution. Then we have evolutions of mentality. In the old days, when a person did a crime, all right, he was found guilty, and they hung him, and that was it. Did it matter that he was 10 years old, 12 years old, 8 years old? Did it matter if the crime was a petty crime like pickpocketing? No, it didn't matter. In the old days, in our early America, if a young boy, 12 years old, pickpocketed, he could be found guilty of pickpocketing, and his punishment would be to be hung. And he was hung. But how do you hang a 10-year-old? They're too light to be hung. So it's obvious the hangman would jump on their legs to make sure that they would die. This was our country way back in the 18th century. That had to come to a stop. Thank God through evolution, it did come to a stop. We no longer have death penalties for 18-year-olds that can't be punished. Not only death penalties, our courts have held we can't even put a child under 18 in prison for life for a crime, except for a capital crime of murder. If any other crime, they've got to be given a chance of parole. Why? Because our high court judges have recently decided that a young man, as he grows up, his mind changes. The mind of a child, 12, 13, 14, 15, 17, is still young. But he's 35, 40, 45, 50, it's different. So therefore, a young man at 15 who commits a terrible crime, put him in jail for life for it? No. You can't do that except for substantial murderous crimes. Give him a chance to parole. Give him a chance to get out. Give him a chance to redo his life. His ideas can change as he becomes older. That's pretty modern. Nobody ever heard of that. And one of the most important changes of all was the question of insanity. What about an insane man? Should an insane man be put in prison? Well, seriously, no, definitely not. But who ever heard of insanity in the 18th century? It never existed. Didn't exist in early English law. But in early English law, there was a case where the prime minister was shot, killed by an insane man, a man who didn't know what he was doing, and he raised the defense at the trial for the first time. Lords, he would say to the English court, please, don't punish this man, our client. He didn't know what he was doing. He had no idea. He thought he was killing a monkey. He didn't know he was shooting at a human being. That's ridiculous. How can a man not know? Well, at that time, there were sufficient doctors who did say, yes, there is a disease that can happen to a man's mind where he doesn't know the nature or quality of the act. He doesn't know right from wrong. And we should consider that before you put a man to death. And English courts agreed to do it. It's called the McNaughton rule, where a person is laboring under a defect of reason and he doesn't know the nature or quality of the act or that it is wrong, he's mentally insane. Now that's a pretty tough standard, or that it is wrong. How do we apply that? Well, when Abraham was told to kill Isaac, Abraham said, God told me to do it. And he was about to slit the throat of Isaac. Of course, he was stopped by the angels. But if he had killed Isaac, would he, by that law, be found guilty of murder? No. If he honestly believed that what he did was not wrong, he's mentally insane, even though by other standards it would be considered wrong. So, we apply that to this very day. If a person doesn't know what he's doing is wrong, he's considered mentally insane and can't be convicted of a crime, let alone competent to even stand trial. And we have that problem, where Berkowitz claimed, a dog told me to kill the man. Or somebody else would say, I didn't know I was killing somebody. Of course, the trouble with that is, you got to convince a jury that it's true. And the jury will not buy it. They know it's phony and they won't accept it. It's a very hard defense to prove. But sometimes you get away with it. Remember this woman, Ann Yates? She took her 5 children, each one of them, and drowned them in the bathtub in her home. Then she called up the police and she said, I just killed my 5 children. She was found guilty of murder, but doctors said this woman is mentally insane. She doesn't know the quality of her act. She's mentally disturbed, a severe psychosis, call it psychopathic, whatever it may be. Well, the jury didn't believe it, and they said no, she was found guilty of murder. However, on appeal, the courts reversed it, and they found a new trial, and they found her guilty, but a defense of insanity applied, and she was not put to death, but served to prison. To me, she was clearly guilty. She called the police. I killed my children. That's clearly an acknowledgement. What she did was wrong, but it's up to a jury. Defense of insanity is a tough defense. Sometimes it works, sometimes it doesn't. Usually it works best as an excuse to a justifiable murder, which is not justifiable, but murder, but you don't want to put the defendant into jail. In particular, we have the case of a young woman who was raped, and her defendant, her assailant, is brought into court smirking and smiling, and the father of that girl, whose life is now ruined, who's mentally disturbed, who will never get over that terrible thing that happened to her, he became so incensed, he grabs a policeman's revolver out of his holster, aims it at the guy, and shoots him, and then drops the gun and gives up. Is that man guilty of murder, of killing that rapist? Of course he's guilty of murder. He can't take the law into his own hands. That rapist is entitled to a trial. He's considered innocent until convicted by a judge or jury. How dare you kill him without a trial? He's guilty of murder. But when he's tried for murder, what's his defense going to be? Temporary insanity. I was so incensed by seeing this man come in and what he did to my daughter. I didn't know what I was doing. I don't remember what happened. I'm sorry that I did what I did. I just don't recall it. And the jury will acquit him in 100% of the cases. So insanity at times can be used. And then we have another type of thing that evolved from the law, which never had before. It's called illegal evidence can't be used in a trial against a defendant. Now, who ever heard of that? What do you mean by illegal evidence? Well, we all know under our Fourth Amendment that policemen have the right for search and seizure. They can go in, search a item, get the item, and if it's properly made under a court of probable cause and even at the order of a judge, it's admissible in evidence. But if the evidence is obtained illegally by torture or stolen or obtained other than by court order, the courts have held it's not admissible in court. Well, where did that ever come from? That became from the judges who decided that's only fair. And how did that work out in reality? It worked out very unfairly. A gentleman by the name of Von Bulow had a lovely wife who had, unfortunately, diabetes, but they had their matrimonial problems, and he wanted to kill her. So the best way to kill her is to give her an injection of insulin, which they'll never find the needle mark. She'll get low sugar, she'll die, she had problems, and he did that. Unfortunately for him, the police were looking in the apartment, and they found a closet, opened it up, and there was a bag of needles and bottles of insulin. So we had the wherewithal to do it. And they tied it in, they found puncture marks on the body of the woman, and they charged her with murder. But his lawyer, Dershowitz, my idol conservative counselor, he argued, Your Honor, that insulin bag was obtained by the police without a warrant, a search warrant. It was illegally obtained. And under our law, we can't permit evidence in the court illegally obtained. That evidence must be suppressed. And the court said, you're right. And they suppressed the evidence, and Von Bulow got away with it. Unfair, but that's the law. Probable cause is a wonderful law that came about. Illegal evidence can't be admitted. But that's in the criminal law. The law has changed very effectively, and we got away. We have these new principles that came into effect. What about civil law? Has the civil law been changed? Very much so. Way back, if a person committed a crime and killed somebody, a man's wild animal, they would take the man's animal and put the animal to death, and that was justice. Nobody ever thought of compensation, paying a person for pain and suffering. But the Bible, for the first time, acknowledged if somebody has injuries, they can be paid certain sums of money as compensation. That's quite a change. And then the biggest change in the law came in our law, how it differs from English law, in negligence. What is negligence? Negligence is where you do something which is violating the laws of probability, where you cause somebody an injury. The question is, are you responsible for your carelessness that causes somebody an injury? The question is, does the injury have to be related to your carelessness? And how is the relation obtained? Who decides it? And what does it mean? And how do you instruct it? Well, that goes back to ancient English law. Under ancient English law, they use the principle of natural and direct result of a person's act. So, as I said to my class in current events, if for the want of a nail a shoe was lost, the want of a shoe a horse was lost, the want of a horse the messenger was lost, the want of a messenger the battle was lost, the want of a battle the war was lost, the want of a law the nation was defeated. Can you blame all that to the blacksmith who didn't put a nail in the shoe? It seems silly, but under ancient English law the answer is yes. If you have a direct, natural, proximate result from a person's act, that liability follows, damages will follow. That was the law of England. But our court said by Justice Cardozo. Justice Cardozo is one of the greatest judges in the New York Supreme Court. He was so wonderful, he was elected all the time, even put up on the Supreme Court of the United States. But he won the elections in New York. Why? Because fortunately, the Italians voted for him. They thought he was an Italian. But everybody knows Benjamin Cardozo was a Sephardic Jew. Had they known, they never would have put him in there. But that's not the problem. But he had a serious question. How far can we go with this concept of direct, natural, proximate cause? That's ridiculous. And along came a woman by the name of Mrs. Paulsgraf. She was sitting on the railroad station waiting for a train. On top of her was a scale wobbling on a wall. But it was up there, secured, wobbling, but there. Well, the train came in the station. The train's pulling out. A man ran to catch the train. He was carrying firecrackers. I kid you not, the true story. Carrying firecrackers. He ran to the train. Conductor pulled him on the train. He dropped his firecrackers. They hit the third rail. They exploded. The concussion traveled hundreds of feet, hit the scale on the wall. The scale was wobbly. It toppled, fell on Mrs. Paulsgraf's head. She now sued the railroad, Long Island Railroad, for the negligence in pulling that man on the train. There was negligence pulling a man with firecrackers on a train. But is it within the realm of probability that a firecracker would explode, that would cause a concussion, that would knock the scale over and fall on her head? Justice Cardozo said no. We stopped with that and we won't follow English law. We don't believe in natural direct consequence. We believe in proximate cause. Is it within the realm of foreseeability? And it is not within the realm of foreseeability that a concussion would happen the way it did. So that's the law of negligence in our state, here in Florida, as well as in New York. And jurors are instructed that. You decide that speeding was within the realm of probability that X would happen. And that's the answer to it. Well, Cardozo gave another wonderful law. The law in negligence is when you volunteer, you can't be liable. If you put yourself in a position of danger and nobody asked you to do it, you volunteered. So if you got hurt, don't blame me, the wrongdoer. I didn't ask you to jump in. He who volunteers sustains no injury. That was the law of our land for many years. Well, along came a young boy playing a ball on the street. The ball went into the street. The boy ran out to get the ball from the street. A car was speeding. He couldn't put on his brakes on time. He was going to strike the child. But a pedestrian saw the kid about to be hit by the car. The pedestrian jumped into the street, pushed the kid away, and the car ran over the pedestrian's leg. Lost his legs. He now sued the car driver. Car driver said, wait a minute, you can't sue me. Who the hell are you to volunteer to save that kid? I owe a duty to the child, but not to you. You volunteered, you can't seek injury. Unfortunately, or fortunately, Cardozo said, wait a minute. All danger invites rescue. It's within probability when you create a dangerous situation that someone is going to jump in and try to save somebody. You owe a duty of care not only to those within your proximity of danger, but to those who volunteer to come in and save somebody. Danger invites rescue. Wonderful concept, thanks to Cardozo. And then we have another concept, criminal law. This law of proximate cause does not apply when a superseding cause comes in to interrupt it, a criminal act. If a criminal act comes in, that's not foreseen. You can't foresee a criminal act. Therefore, I'm not responsible if a criminal act comes in for something that I've been negligent. That seemed to be the law, and it was good law, except for Connie Francis. Connie Francis rented a room once in a hotel, but the hotel had a room that had a defective lock on it. And it was in an area there were burglaries, break-in, robberies. Criminals would come into the hotel all the time. She pleaded with the hotel, could you please correct the lock on my door? Oh, we'll take care of it, don't worry about it. They didn't take care of it. So Connie Francis went to bed one night. Unfortunately, some felon got into the room, came over to her room. The door was easily opened, the lock was broken, came into the room, sexually assaulted her. Needless to say, she was devastated, and she sued the hotel. And the hotel said, look, we admit, Your Honor, we should have fixed the lock. We're sorry about that. And what can we say? But here's a criminal act of somebody coming in to cause sexual assault. That a superseding, intervening act, we're not responsible for that. That's beyond proximate cause. It's beyond Paul's Graph versus Long Island Railroad. It's a superseding act that we can't anticipate. It's unreasonable. The judge said, no, it is not unreasonable. That is within the foreseeability if it's something like that happens. So today we now have damages can be had for that type of criminal activity. Then how about the man who is suddenly frightened by an act and suffers a heart attack? Can he sue? For the damages for the heart attack, yes, but what if he didn't have a heart attack? He's just mentally frightened and terrified. Can he have a cause for mental fear? The law used to be no. There only could be damages when there are physical injuries. Well, a case, a guy was on an airlift going up a mountain. He's put on one of those elevators that bring you up the mountain. And unfortunately, the bars that secured him to the seat opened up. He was about to fall hundreds of feet below, hanging on to the ropes, terrified. He was landed safely at the other end, but his fright was horrendous. And he sued the ski lift because of its defect, which caused him mental pain. Could he recover from mental pain? Absolutely, and he was able to recover. So the law allows that recovery. And again, that's an example of how the law changes. Mental damages and physical damages are good. But sometimes mental damages go out of sight. I used to work for Jacob Fuchsberg, a great negligence lawyer, became a great judge in New York Court of Appeals. And he had one day a woman came to him with tears, an elderly lady, crying, oh, my poor papa, he was killed on Queens Boulevard by a drunken driver. I want to sue the man for everything he's worth. Calm down. This is Mr. Fuchsberg said, what happened? Oh, this driver hit my poor daddy. He's 90 years old. Oh, it was terrible. And killed him. I want to sue them for millions of dollars. Well, calm down. How old was your father? Oh, he was 90. Was he working? No, he doesn't work at 90 years of age. Did he support you? Of course not. He had no money. He couldn't support him. We were taking care of him. Did he have a wife? No, my mother died. His wife died years ago. Did he work at all? No, he was retired. He didn't work. No support? No, he didn't take care of us. He had no wife? No, his wife died. Did he suffer any pain from that automobile incident? Thank God, she said, alibi. When the car hit him, he went straight up and came down and died immediately. No suffering. Oh, wonderful. Did he have any medical bills? Of course not. He died right away. We had a funeral. That was the end of it. He folded up the case, handed it to her. Goodbye, can't take your case. But my husband is spending, he's negligent, he got blah, 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 blah. There are no injuries in New York law to warrant that type of recovery. No special damages, no loss of income, no pecuniary support to anybody entitled to it. The man had no pain or suffering. We can't sue. So since then, New York has a wonderful law, and I'll give you this free advice. If you're ever in a car accident where you run over an old man, the first thing you must do, look in your rear mirror. If you see him sit up, immediately back up and kill him. Because the longer he lives, the greater will be your damages. Anyway, that was all right. All right, that's of course taking off a silly joke. And the other advantage of civil law is, of course, what we all know, civil rights. That was the greatest thing that ever happened. Greatest thing in our history of evolution. The evolution of civil rights. Thank the Johnson with his Civil Rights Act. But before that, the Supreme Court is involved. The Supreme Court is a perfect example of how the law is viable, how it works. Let me know, but I think I'm going too much, because I can go on for a little bit.
Keep going.
Under the Supreme Court, they decide our law of our land. We have serious questions, though. Do they read the Constitution as it is written? Do they make a judicial construction? Or do they make judicial legislation? Maybe they're reading to it more than they should. But the Supreme Court has read into it in different ways and has changed its ways when the mores of society have changed. The classic example, which you're all well aware of, is Plessy versus Board of Education. The schools can now be set up separate for blacks, separate for whites. Restaurants separate for blacks, separate for whites. Restrooms, gas stations, soda fountains, water fountains. Nothing wrong with separate but equal. That's not prohibited by our Constitution. That was the law of the land, which every one of us, sadly enough, lived through when we were younger. I remember going down south with my folks before I-95. We stopped at Bed and Bath and a lot of these places. White-only signs. You went to restaurants, white-only signs. I had a picture of a white-only sign. I wish I kept it, but I lost it. It's quite a thing. I knew it was wrong at that time. Going on the Baltimore ferry, I wanted to walk around the ship as we were crossing down south, and the sailor on the ship, one of the seamen, said, "Oh, young fella, you can't go into the back. It's not a good idea." "Oh, is it prohibited?" "No, but I wouldn't go there." "Well, I just want to walk around the ship." "All right." I walked into the back, opened up the door, all black people in the back. In the front were all white people. They were isolated in the back of the ship. They saw me come in, dead silence. I walked through and I felt most uncomfortable. It was a terrible feeling, separate but equal. Finally, I went up to the Supreme Court of the United States, and of course, in Brown versus Board of Education, the Supreme Court said very succinctly, you can't have a Columbia P&S medical school for blacks. You can't have a Harvard Law School for blacks. You can't have separate but equal. In and of itself, it's unconstitutional. The law has changed. And of course, that's a wonderful Supreme Court law. But then you have other problems. One of the greatest judges on that bench, Scalia, said, wait a minute now. We can't keep making law that's not in the Constitution. If it ain't written in the good book, it should be the law. Perfect example, the famous Miranda rule. Under our Fifth Amendment, no person can be a witness against himself. I discussed that. You understand that. It's a good rule. You can't ask a defendant, did you do the crime? He can't be called to court. Not only can't you not ask him, a judge will instruct the jury, you can't infer guilt by the silence of the defendant. He's got a right to remain silent. The burden is on the state to prove guilt beyond a reasonable doubt. Well, that's wonderful, but along came the concept of, shouldn't you at least tell the defendant you got a right to remain silent? Anything you say can be used against you. You can't afford a lawyer who'll give you a lawyer. Shouldn't that be reasonable and fair? Well, Scalia said, yes, it is reasonable and fair, but you don't have to tell him. That's his job to know the law. He should know the Constitution. Don't tell him what his rights are. It's ridiculous. Oh, that's Scalia. And was he right? I happen to think he was right. But the Supreme Court said wrong, and they have the Miranda rule, which we all know by watching all the TV shows Every time you are arrested, a policeman has the right to stop you. Yes, but he has to give you this warning. You have a right to remain silent. Anything you say can be used against you. The Miranda rule. An example of the court going out of their way. But what is a judge's duty? Conservative or strict instruction? It all depends how you want to look at it. I can spend a long time talking about it, but I really won't. But the question does arise, and it's a good serious question. Our Constitution, which I love, is it sufficient? Does it cover all the topics? Should it be amended? I say yes in about 5 different categories, and then I'll end my discussion. I think the Constitution is good, but what about the right to declare war? Can the President declare war without the consent of Congress? In the Constitution, who has the right to declare war? Only Congress. But Congress passed the War Powers Act, which gave the President the right with their hostilities to declare war for a certain period of time, justify it to Congress, ask for more funds. Within 60 days, Congress can deny funds and end it or continue it. But the President has the right to declare war on his own in certain hostile situations. Now that's quite a delegation by Congress to the President. Is that constitutional? I say it's not, but it's never been tested. Why is it not constitutional? Because years ago, Congress passed the law of taxation, which is the right of Congress. But it said in its law, all of these items will tax, but Mr. President, if you don't like an item, strike it out, and the rest of the items will remain. And they gave the bill to the President. He struck out 1, 3, 5, 7, the rest he signed. The Supreme Court held unconstitutional. Mr. President, you have only 2 functions: sign the bill or veto it. You can't decide what is good and what is bad. That's the Congress. They can't delegate to you that which is exclusive within the congressional power. Taxing is their power. They give you a bill, sign it or veto it, but you can't pass it. Well, if that's the law when it comes to taxation, why not apply that law to the right to declare war? However, nobody's asked me to take the case. As of now, that's still the right of the President, and he's done it. You may recall he sent troops into Panama to pull out, I forgot the name of the guy, that drug lord, and they got him out. Noriega. And then Grenada. The United States sent troops into this island of Grenada to save our students from being suppressed by the Grenada government. Congress declared war, so those are serious problems. So declaring war is one thing, and maybe the President should have that right. How about birthright? That's a very serious problem. All those born in the United States are natural citizens thereof, subject to its jurisdiction. Should a person who comes here solely to be born here be given a U.S. citizenship? That goes against all that's decency in our minds. That's one thing when the law was passed to protect slaves who were born here, who are no longer slaves, they are now citizens. Or people who come here legitimately, have children here. That's fine, they are citizens. But to have, and Chinese people do it quite often, they send their pregnant young ladies over here just to give birth so they can become American citizens. That law should be changed. That amendment should be changed completely. And that's the Section 2 of the Constitution. How about the other problem that says, natural-born citizens shall be eligible for office of president? In today's day and age, is it so important that you be born here to be president of the United States? Kissinger was a brilliant man. What if he wanted to run for presidency? Could he run for presidency? No, he's not born here. Schwarzenegger, you may not like him, but he became quite popular in California. What if he wanted to run for president? He can't run. I think that section should also be changed. How about the questions of terrorists being battlefield detainees? Are they entitled to the Constitution of terrorists? Yes. Anyone born in this country or in this country, wherever the flag flies, our law applies, and they become subject to our law, whether you're here legally or illegally. And that's the law of our land. Maybe that should be changed. Terrorists should not be given all the benefits that we give. A man from Mexico robs a bank. He's put in jail for 5 years, and he's now set free. Well, fine, you're going back to Mexico. We don't want him. Well, we're sending you to Iran. We don't want him. Yemen, we don't want him. Iraq, we don't want him. What do you do with him? He served his 5 years. He's now entitled to be set free from jail, but no country will take him. Literally, he's allowed to be set free in the United States. What do? Put him on a ship, the man without a country? No, we have no laws covering that. That should be considered. What I consider most important is the problem of a president whom we do not like. We feel his policies are wrong. He shouldn't be president. I think that's somewhat familiar to you people today. We have an argument about that. What do you do with someone whom you don't like, whose policies are wrong? who is not helping the country. I'm not saying that's so. That's another issue, but I'm giving you a hypothetical. Can he be removed? No. There is no way you can remove him. You can impeach him if there's a crime involved, if he committed a high crime or misdemeanor. But subject to impeachment, there's nothing you can do about it. He stays for 4 years whether you like him or you don't. And you will know impeachment doesn't always work. Bill Clinton, they built impeachment out, but they wouldn't impeach him over a sexual issue. So impeachment is not sufficient. You got to live with someone who is no good. I'm not saying that applies to Trump. I'm saying the hypothetical. That if a president does exist who is not doing his job, you can't get rid of him. Oh, we do have the 24th Amendment or 5th Amendment that says if a president is mentally unable to fulfill his duties, he can be removed temporarily. Vice president takes over by the cabinet and by Congress, and he remains until the president is well again, then he goes back into office. Of course, that would be a perfect thing for Trump to do. He could have his doctor write a letter that he's mentally upset with all that's going on. He can't perform the functions of his duties, and he therefore withdraws as president and hands it over to Pence. And Pence becomes president. And then 2 days later, Pence gives a pardon for Trump for anything he may have done in office, now and in the future. That was done with Nixon, remember? And then after he gets the pardon, all of a sudden, Trump says, I'm well again. I now feel fine. I'm back in office. And he goes to become president. Scenario that's not going to happen. But the point is, how do you get rid of a president who is not popular? Well, we have in Israel, France, England, Germany, a parliamentary form of government. If the prime minister, who's like the president, is not satisfactorily doing his job, his policies are not working, people don't want him, they simply immediately, no confidence, out he goes and they pick in a new prime minister. They have no term limits. He's not elected president for 4 years. He serves at the suffrage of Parliament. We don't have that in our country. Maybe something like that could be put in the Constitution to give perhaps the chance that our president can be removed if he's not satisfactorily doing the job. So the bottom line of my speech today is, does our law work? Yes. I showed you how it has evolved from Hammurabi up until today in our Constitution. I try to show you how the greatest document we have is our Constitution, how blessed every one of you should be to live in this God-given country that has that wonderful doctrine of James Madison, who wrote the Constitution. James Madison, who also gave the Bill of Rights, which was added to the Constitution after it was written. That's not part of the Constitution. That was submitted later on, and it was passed by the states. A wonderful document. May the Constitution in our country live for 1,000 years. Thank you. Any questions? Yeah, Arnie.
A couple things. I don't know how many people saw the movie last night.
Yeah, on Ginsburg.
About Ruth Bader Ginsburg, about the first. Did anybody here see it?
Yeah, we don't, most of us
Okay.
saw it.
Very, of course, it was a dramatization, and you got to take it as that. But there was one line in there. I wish I could remember that, or one of her professors, something about. The law is a living document. It changes as time changes, and the laws change. I don't remember something about the wind. I don't remember what the doctor did. But basically, I take objection to you siding with Scalia on if you take a 19-year-old kid who didn't graduate high school, and he's picked up on a crime, and he goes and he's in a police station. And what are the police trying to do? Get as much evidence, and sometimes they would interrogate a guy for 20 hours. How the hell does he know his rights? How does he know his rights?
Well, that of course is Scalia's argument that
Well,
you can't tell him.
How do you justify your agreement with them? You agree with them?
Yes, because the concept is everyone is presumed to know the law. I know that's silly, but if you argue that everyone must be told the law, what if the guy says, I'm hungry and I stole a loaf of bread? I don't think that's illegal, I'm hungry. Is he knowing the law? He's presumed, would you acquit him? No. He's guilty of stealing, whether you know the law or not. It is the law of the land and you're duty bound to know it. That's how we have stability in our government. But you're right about the extensive questioning. They can't harass him and do that sort of thing. That's wrong. And maybe he can argue that he's being suppress that he's being overborne, and he can't actually think about anything because he's being brutally beaten. My fortune, 20 hours of questioning without rest and food or drink or water, that may be another issue. But certainly to give him a warning, well, Miranda says yes. I think Miranda is wrong. I agree with Scalia on that one. It's not in the good book. You know. How about abortion? Where is it written in the good book a woman has a right to have an abortion? It's not. But the judges said a woman does have that right in a non-viable situation.
Well, getting back to the police, how many times do the police get some young person in there and they say, if you confess to it, we're going to get you a good deal?
That's wrong.
And that happens
That's
often.
wrong.
And you have case upon case.
That's wrong.
I totally disagree with you.
All right. There's the exit. Get out of here.
I can't.
All right, I love you.
Right,
No
there's no
problem.
law.
Okay, we're on the back burner. Gordon.
What about the basic judicial system we have in this country, where someone is innocent until proved guilty, as opposed to England and I'm not sure where else, where it's the opposite,
Yeah.
that they're
Yeah.
guilty and you have to prove them.
That's right.
Give me your
Yeah,
ideas
it's a
about
good
that.
point, but as I said, our concept of the Fifth Amendment, you can't be a witness against yourself. Only in this country does that happen, where a defendant is obligated to say nothing. And they can't ask him or even impugn from his silence that he's guilty. In all the countries, in England and Germany, every country, even you think in Israel, they don't have the Fifth Amendment. They have a right to ask a defendant, did you do it? But as I told you, the history was they would torture somebody to get him to admit that he did it and then put his confession in court against him. So to stop it, they now say, you can't do that. You can't be a witness against yourself. But they'll take your picture, they'll take your DNA, they'll take your blood sample, you'll put up in the lineup. It's pretty much testifying against yourself. But from your lips, no. But it seems to be cruel, but in all the other countries, they don't have that Fifth Amendment. We have it in this country, most unusual. But it's a good thing, it really is.
Yeah, but what about that you're presumed that they have to prove you guilty? Not that you have to prove yourself innocent.
Yeah, well,
without testifying.
our country does say you are presumed innocent. But remember, a finding of not guilty by a jury doesn't mean that you're innocent. O.J. Simpson was found not guilty by the jury. All the evidence was got the blood, the pants, the shoes, everything. The man was guilty as could be. But unfortunately for O.J., with the family of the victim, the policeman used the N-word in interviewing a few black people. And the jury in the O.J. case was primarily black. And when they heard that, Furman, I think his name is the detective, when they heard on cross-examination, Mr. Furman, did you ever use the N-word in any interview with people on articles you wrote? Oh, I never did. And they showed an article that he wrote where he said the N-word. Well, I guess I did say it. Once the jury heard that, there is no way they're going to convict O.J. on the basis of a white racist guy like that who uses the N-word. No different than in a criminal case where a Jew is on trial for murder and all his jurors happen to be Jewish, and the main prosecutor against him finds a detective with the main evidence who once said, all Jews should go up and smoke in Auschwitz. If that ever came out in the jury trial, those jurors would never find that defendant guilty based upon what that testimony is. So therefore, that testimony was perhaps unfair in use. But the idea is you are presumed innocent until proven guilty. That's our law. But it doesn't mean you're innocent. And on the contrary, can you be tried again? No, double jeopardy. That can't happen. But in the indictment stage, which is interesting, in the indictment stage, a prosecutor finds only probable cause that you did the crime. Once he shows probable cause, the jury comes in with an indictment, which means you're now tried before a jury on the crime. But in the trial, you got to be found guilty beyond a reasonable doubt. That's a very tough standard. But once the jury comes in with not guilty, that only means the standard of beyond a reasonable doubt has not been met. It doesn't mean that if there was a photograph of you shooting the guy, that would have found you guilty. Sorry, at the trial, we had flimsy evidence, not enough to prove guilt beyond a reasonable doubt. Therefore, we acquit, you're presumed innocent. It's a tough call, but that's our system of justice. I hope that answers it. Yeah.
Yeah, there's something very wrong about criminal justice system. And close to 40 to 50% of all people who are in prison are African Americans and Hispanics. And the reason is because most of them can't afford a good lawyer, you know? And so the criminal justice system really affects people of the lower classes. And that, I want your comment about
No,
that.
you're absolutely right. That's why we now have in Florida, they're now saying people with certain type of criminal offenses should not be put in jail. The Supreme Court is now changing its rule on people being convicted of carrying drugs, opium and crack, powdered, and the other is two extremes. Don't put a guy in jail for the lesser crime the way he is. And the person being put in jail because of race, color, or creed, it's true, it's sad, just because they're black. Look what happened tragically in the Roger case here in Florida. There's a policeman. There's an example of a case that the color made all the difference in the world. Tragically, prejudice set in, and now two families are suffering. You know that case. Roger is a Florida policeman, an undercover cop, driving a car not marked, patrolling the Parkway I-95. Along came this guy Jones, a black man who was a band leader, a band drummer, innocent man, loving to play the drums. His car conked out. It's parked on the side of the road. There are no lights. It's a dark area. He's waiting for help. And along came Roger's police car. He's a policeman in the car doing service at night in an area, meaning not at all, just minding his own business. He sees that car parked in the dark. He stops his car, goes over to see what's happening. Unfortunately, what happened is, he said, "Are you all right?" And the man in the car said, Jones, "Oh, I'm okay, officer. I'm fine. I need help. The car is red." And as he approached them, "Are you sure you're all right?" "I'm all right." But then he saw the man was black. What's that got to do with it? I think everything, in my opinion. Because then, "Are you sure you're all right?" "I'm okay, officer. I'm okay. I'm fine." And he reaches inside to pull out a cell phone. To the policeman, he's going for a gun. And in his mind, blacks kill cops. On this area, this guy's black, I'm in big trouble for my life. He takes out a gun, bang, and he kills Jones. And to make it worse, he lied about it. He then tells his policeman, "Oh, I gave him a warning. I told him I'm a policeman. What can I help you?" The fact is, Jones had a telephone which was on, and the telephone didn't show the policeman gave that warning. He shot first and then gave the warning when he called back in and detected his police station to tell him, "I just killed a man. I warned him that I'm a policeman." He was lying, and the result, the jury found him guilty of murder, which was right. He obviously killed that guy without probable cause at all. Clearly a terrible example of prejudice, and now he's had 25 years in prison, and he won't live very long in prison if he's allowed to mingle with those black prisoners. The majority are black. Though it's an example where we have an unfortunate society where blacks are presumed guilty and they're punished more strongly for it. I remember I was in New York City when I was practicing. I was on 47th Street on Broadway around the area trying to get some tickets for a show, and I'm walking on 8th Avenue, and a car was stopped by possibly violating the red light on 8th Avenue and 46th Street, and policemen were in the police car behind them, and they both came out of their car, and the car was being driven by 3 black men. The policemen came out of the car. First thing the cops did, unbuckled their holsters of their guns. And then one cop went over to talk to the driver. "May I see your license, please?" The second cop followed right behind him, ready to pull out his gun. Would that have happened if the drivers were white? Probably not. The answer is what? How many people commit crimes more than others? I guess blacks do. Statistically, there are more blacks in prison. Statistically, they committed more crimes. So we have prejudice. But how do you control that situation? You can't. It's a tough call. Yeah, let me get a question about
What
you.
happens if I commit a crime and I say,
You would do that. Knowing you, never gonna happen.
or then I say, I lost my mind mentally, if I shot somebody. Now, how could you prove that I did not lose my mind?
Oh, well, the burden is not on me, the state, to prove that you didn't use your mind. The burden on you to prove that you didn't lose your mind. You got to bring psychiatrists who examine you and
Well,
testify.
can't a person fake it?
You can say it, but the presumption is of course, that you're innocent. I gotta prove you're guilty beyond a reasonable doubt, that you have that affirmative defense. Will the jury believe you? You gotta convince the jury that you lost your mind. And if you said the dog told you to do it, who's gonna believe you? Berkowitz tried that.
No, I'm just saying, can't a person just fake it?
What's that?
Can't a person just fake
She's
it?
saying to fake it.
Can you say it?
Fake it.
Fake it.
Well, can you fake it? Sure you can. But a jury, in most of these cases, the jury say you're faking it. It's not true. But if you killed, by example, that rapist who came into court and you're the mother of that child,
That's different.
your jury would believe you even though you're not insane. They won't put you to jail. By the way, we have that concept in our law, which is no other country in the world. It's called jury nullification. A judge can give the jury the law, but they can disregard it. My uncle had that. He was on a case where a young girl, 16, was pregnant, and she didn't want the baby. She went to some quack doctor did something to her terribly to kill the unborn child. She got the abortion, but she'll never have a child again. The doctor was charged with manslaughter. She was charged with second-degree manslaughter, submitting to an abortion when she was pregnant, which was illegal in New York at the time. And she was on trial for abortion. And she was on the witness stand, and the prosecutor said to her, "You were pregnant at the time you went to that doctor?" "Yes, I was." "You knew you were pregnant?" "Absolutely." "You knew he was a doctor?" "Yes." "And you wanted the abortion?" "Yes." "And you went there?" "Yes." "And you did it knowing that it would be a crime to have that abortion?" "Yes, I did it, but I didn't want my parents to know." Tears coming down her face. "No further questions." And he stops. She comes off the stand. The parents hug her and kiss her. The judge instructs the jury, "I instruct you, if she knew she was pregnant and she went to a doctor while pregnant and she went to get an abortion and this doctor was not a legal doctor authorized to commit an abortion, that violates section blah blah of the code, you must find her guilty." That's the law. I so instruct you. The jury went into the jury room. My uncle was on the jury. They sat down. They looked at each other. The head foreman of the jury got up and said, "What are we doing here? Did you see that girl? That 15-year-old girl, that lovely child, crying, her tears pouring down her face. She didn't want the child, the humiliation of having a baby at her age. She made a mistake. She went to a bad doctor. Did you see how she tears coming down? And then her parents, they hugged her, they kissed her, they loved her. What are we going to do? Put her in jail? That's going to satisfy the public weal? Put her away for 5 years in prison? Let this child go. She's got enough troubles. She'll never have a child again, what that doctor did to her. But she's got loving family support. Don't convict her." The jury was in tears, and they all came back. "How find you, gentlemen of the jury?" "We find the defendant not guilty." Well, the girl was smiling. She went back to her family in tears. They hugged her and kissed her. They blessed the jury. The judge was livid. "How dare you jurors disobey my instructions? Your job is to follow the law, not to change the law. Apply the facts to the law. You have no right to not do it, blah, 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 blah." But the judge could do nothing. When the jury says not guilty, that's it. It's not guilty. Can a judge now overrule a verdict? No. Once a jury says not guilty, you go home, and you can't be tried again. On the other hand, if you're found guilty, you go to the judge. "Your Honor, the jury was prejudiced," and he can overrule the jury and find you not guilty. But a judge can't do the reverse. So there's an example where a woman can claim she's insane and get away with it with the Red case, or in my case, and jury nullification. We have a wonderful system. It really is, and it works. Anybody else? Yeah.
In Las Vegas, all of the murders, the killings, and the people held stuff back, and the case still hasn't been worked out, right?
What case is
The
that?
murderer in Las
The guy who
Vegas,
shot through the windows.
the mass killer.
Oh, the mass killer, yeah.
Somebody controlled all the information
Well, that's the administration system. Sometimes you get an early trial, sometimes they delay it. Yeah, that's unfortunate. That's one of the problems. Justice delayed is justice denied. It's unfortunate, but that's the way it goes. Same people complain also when there is justice done, a man is found guilty, he's not put to death right away. It takes years before it finally works itself through the appellate courts up to the Supreme Court of the United States, if possible. Is that fair? It takes so long. That's cruel and unusual punishment. By the way, I'm of the opinion that sooner or later, the death penalty will be found unconstitutional. Eventually, they're going to find it is cruel and unusual even to kill somebody. Cruel and unusual is a very important concept we have. In Florida, it used to be cruel or unusual, but they amended it, being technical, to make it cruel and unusual to comply with the federal law. The law can be technical and a problem. Once a guy went to a judge and said, Your Honor, I'd like to get married, can you marry me? The judge says, where's your marriage license? I don't have one. Go to the marriage clerk and get it. He goes to the clerk, comes back, the judge says, where's the notarial certificate? Without that, it's not a valid license. Go back and get it. He goes back and back. Where's the date of expiration of the notary? It's not in there. Go back and get it. He goes back. Where is the county in which the notary was taken? It's not in there. Go back and get it. He goes back. Now it's a valid marriage certificate. I want you to know something, young man. If I married you into an invalid marriage certificate and you had a child, that child will be known as a technical bastard. The guy starts to smile and laugh. Why are you laughing? He said, that's exactly what the marriage clerk called you. Okay, that's it. Thank you. I hope, unlike the men on the blimp, you learned something. Thank you for having me.
Thank you for coming.
Thank you.